do. So we've worked through our break. So we'll go straight to the next paper on the economic costs of pretrial detention. So I see we have Will Doby, one of the authors here, and the discussants are making their way in. So I think we're ready to begin. So the next paper is called The Economic Costs of Pretrial Detention by Will Doby and Crystal Yang.
Well, thank you so much for having me. It's a pleasure to be here today, and thank you to the discussants in advance for the really thoughtful comments that they included. So today, I want to talk about the economic costs of pretrial detention and why we think that pretrial detention and more generally the criminal justice system might have important macroeconomic implications. Now, just at a very high level, the reason this might be interesting at the macro level is that even though the United States only has about 5% of the world's population, we have roughly 25% of its prison population. And the costs of mass incarceration are likely, therefore, potentially significant. An estimated 8% of all of the adult population and 33% of the Black male population have a felony conviction. So to the extent that we think these convictions matter for people's labor market outcomes and their human capital, the numbers become very large very quickly. Now, the part of the criminal justice system that we're going to focus on is the pretrial or bail system. We'll explain why we think that's so important, but in short, it impacts all of the 10 million individuals that are arrested each year. This is typically one of the first interactions that people have with the criminal justice system. And there's a lot of work suggesting that it's a particularly important decision point where the decisions we make at this point can have very important ramifications for years afterwards. So just a very brief review of the pretrial system, because I know not a lot of people in the audience will necessarily be familiar with it. In the US criminal justice system, you're usually arrested for a crime. You have to presumably commit a crime if you're guilty, but you have to be under suspicion, you're arrested. And then within a couple hours or a day or two, usually charges will be filed. 24 to 48 hours after charges being filed, there then will be a bail or arraignment hearing. And this is the step in the process that we're going to focus on, is what happens at this bail hearing. Now, at the bail hearing, a bail judge will make a decision about whether you should be detained outright, whether you should be released with no conditions, or whether you should only be released with some form of monetary conditions. Now, often those monetary conditions are such that people are detained anyway. So in the data we have, roughly 50% of people where there's monetary bail set are unable to pay it or choose not to pay it, and end up being detained for up to months at a time before they're ever convicted of a crime. Now, regardless of whether you're released or detained, you then proceed through the criminal justice system. So you would then be arraigned. You could either go to trial or plead guilty to the charge, and then you would ultimately be sentenced after a finding. Now, by law, that pretrial or bail system is meant to accomplish three potentially conflicting goals. So the first is that it's meant to release almost all defendants before trial under reasonable conditions. So the US, like most countries, has a presumption of innocence. So we're not supposed to be punishing people at this stage. The sole determinant of when we should detain people is that we ensure that people are going to appear at all court proceedings afterwards. We want to make sure that people actually show up and have their day in court. And in many jurisdictions, we want to protect the public by preventing new crime, particularly serious crimes. Now, in practice, despite the fact that it's very clear what the bail system is meant to do, there's a very heated debate on whether the system works in practice. Now, what works can mean different things to different people, but generally the critics of the bail system would say that pretrial detention seems to be the result of poverty, not guilt. So we see incredibly high detention rates among low-income individuals, particularly when bail amounts are very, very small. So even when people only need to pay, say, $50 to be released from jail, they seem to have a very hard time doing that. In addition, there's widespread claims that detention can disrupt employment for those already on the margin. So this can just be a literal direct effect where you're not able to show up to work and you're then fired. Or it could be that eventually there are knock-on effects on the probability of pleading guilty or being convicted, and this can lead to stigma effects that will also make it hard to hold or get a new job. The other issue that people point to in the bail system is that we have significantly higher detention rates for minority defendants, even when we control for rich sets of observable characteristics. So this mirrors many other aspects of the criminal justice system where minority defendants seem to be treated very, very differently than white defendants. Now, as a result of these observations in this debate, many jurisdictions are currently reforming their bail systems or are looking to reform their bail system. And those reforms take many different forms. So some of them are focused on risk-based assessment tools to limit judicial discretion and try to scale back the number of people being detained. Others are focusing on alternatives to bail, like electronic monitoring or supervised release. And finally, many are trying to get rid of bail altogether, either through the legislature or just through community organizations that actually post bail for defendants. So many large cities at this point have organizations that will raise money and are attempting to bail out all low-level individuals charged with low-level crimes. Now, why do we think the pretrial system is going to affect economic outcomes? Why are we talking at Brookings? The first main reason is just simply that there's an overwhelming number of stories about how disruptive the pretrial process is. So this is one quote from a defense attorney speaking in the New York Times, but it's very representative of the stories you hear about how clients who are working in service level positions, if they miss a day of work, they're fired. And then you have that, you have a hard time getting another job, and you also have that on your record. In addition, if you live in shelters, if you miss your curfew, you can lose your housing. And of course, if you have immigration concerns, pretrial detention can also factor into that and potentially lead to deportation, though that tends not to be a factor in some parts of the country compared to others. But the larger point is that when clients have bail set, they have enormous worries about what's happening on the outside. In addition, there tends to be considerable strain on families. So families, one, they're trying to raise the financial resources to pay for pretrial detention, but it also just creates a large emotional strain on everyone kind of involved, from siblings to spouses to children. Now, if we tried to model that, I think there's two different ways that we could think about pretrial detention affecting economic outcomes. The first would be these direct partial equilibrium effects of just what happens for the detained individuals directly. And this would be the idea that there are short-run incapacitation effects that result in immediate job loss, as well as the longer-run destabilizing effects from lower labor demand through the stigma effect. So we show in some of our other work that when you're detained before trial, it seems to really increase the probability that you plead guilty to charges. Much of this is happening from a worsened negotiating position with the prosecuting attorney. Now, the second set of effects that we might be worried about are spillover effects on family members, friends, and the community at large. So this, we're conceptualizing this primarily as negative spillover effects, that by detaining large numbers of individuals from a community, that can be incredibly disruptive and lead to worse economic outcomes for entire groups of people. As well, you might think that there are intergenerational effects, given that just over half of defendants actually have children under the age of 18. So these are not individuals who are necessarily single or very young. These are individuals that have children, and this can be, again, destabilizing to those children as well. And so the broader point is, while most of this talk is going to focus on these partial equilibrium estimates, because that's where our evidence is strongest, I think there are good reasons to think that that's going to understate the economic importance of the pretrial system. Now, in the interest of time, I'm only going to briefly talk about the national trends in pretrial detention, just to give you a sense of kind of what's happening at the national landscape and why the reform efforts are gathering steam given these trends. This is coming from our best available data on bail. So this comes from a representative sample from 40 of the 75 most populous counties. And then you can weight the data to be representative of all those counties. And broadly, what we see is that the detention rate has been slowly increasing over time, certainly through 2005, and that now roughly 40% of felony defendants who are charged in these large counties end up being detained before trial. That tends to be driven by Black defendants who have rates of detention that largely mirror those overall trends, while we see much lower rates of detention for white defendants. Again, this is something that we see in the vast majority of jurisdictions. These are raw numbers, but those same gaps will tend to show up even when we control for a very rich set of observable characteristics. There's a little bit of a decrease at the end of the sample period. Unfortunately, we don't know what's happening in more recent periods, but the little bit of data that we have suggests that detention rates have generally been increasing again. Let me get to the causal estimates and talk about why we think there may be such important economic effects of pretrial detention. So our best evidence to date comes from work that I did with my co-authors Jacob Golden at the Stanford Law School and Crystal Yang at Harvard Law School. And in this paper, we focus on the best available causal evidence of what we can learn from what's called a judge IV design. So what we do here is we exploit the fact that in many bail systems, defendants are randomly assigned to different judges in the system. Now, what is useful from a researcher's point of view is that some of these judges are very strict and detain a large number of defendants, while other judges are very lenient and release a large number of defendants. And so what we can do is track defendants through the system and understand if there are economic consequences of being assigned to the strict versus the lenient judge. We can then scale those estimates by the difference in the probability of detention to have a sense of how costly pretrial detention is on your later outcomes. So what do we find? If you look 3 to 4 years after an individual's arrest, so long after they've been released on any particular charge, individuals who are detained are about 9.4 percentage points less likely to have any formal sector employment. You'll note that the mean is quite low. So that's saying that this is a population that generally has pretty low employment, but it's much, much lower after they've been detained, even after a considerable length of time. Now, linked with that, people are also less likely to get social insurance benefits that are linked to employment. So they're less likely to have any unemployment insurance during our sample period, and much less likely to have any earned income tax credit earnings during our sample period. And again, this is tightly linked to the fact that they no longer have formal sector earnings, and so they're not filing tax returns, and they're just not able to access these benefits. Now, while our standard errors get pretty large when we start looking at continuous outcomes, it can be useful to say, well, what does this mean in terms of actual earnings? And what would this be in terms of the net present value if we're willing to make assumptions about what these effects would be over time? So our best estimates, taking the point estimates perhaps overly seriously, is that this would lead to just under $20,000 in lost formal sector earnings over someone's lifetime, as well as about another $10,000 in lost unemployment insurance and earned income tax credit over their lifetime. So again, I do want to caution that standard errors are what they are here. So, we want to be a little bit cautious with taking these numbers overly seriously. But the idea is that the magnitudes are quite large, and they really back up with our more precise binary estimates based on any employment first done. Now, what do those numbers mean? I mean, what does a 9.4 percentage point decrease mean, or roughly $29,000 in lost earnings and social insurance receipt mean for individuals if we kind of zoomed out and thought of these broad macro reforms that people are considering in the pretrial space? Well, one of the more ambitious reforms under consideration is the elimination of money bail, which our best estimate is that would likely reduce detention rates from around 40% where they are now to approximately 10%. Now, this is very much a guess. We don't know exactly how much judges will offset the loss of monetary bail by detaining more individuals, but I think this is a reasonable guess of where we might end up with overall detention rates. Now, if you take those partial equilibrium estimates seriously from our judge work, that would suggest that a reduction in pretrial detention would increase aggregate income by about $80 billion per year. So obviously a really large number. And those increases are going to be concentrated in low income and minority communities. So communities where income is already particularly low. Now, that's what we know for sure. I think a natural question is whether there is also a relationship between changes in detention and changes in economic outcomes in the aggregate data. Now, I should preface this by saying, we're now moving into less convincing empirical designs. And so we're not suggesting that these estimates should supersede the IV designs, but rather that they're a confirmation of what we're seeing. And they'll help give us a sense of, are the macro relationships that we might expect showing up in the data? So in the absence of really convincing empirical design, we're going to look at changes in detention rate on the x-axis and changes in different outcomes on the y-axis, where we start with the poverty rate in different demographic groups. So we're looking at changes over the 2000 to 2009, 2010 period, because that's where our data is best. And for that time period, we have information from 24 counties. So this is just the raw correlation between those changes, where we weight each cell by the number of individuals in that specific group in that specific county. And so what you can see here is that not only do we have significant variation in the amount of how detention rates have changed over time in these counties, those changes are very strongly correlated with changes in the poverty rate in the expected direction. And so again, I'm not going to belabor what the point estimates are. I wouldn't suggest taking the point estimates literally. I don't think that's the right way to interpret this evidence, but it's certainly consistent with our very well identified work on the partial equilibrium estimates. We also see a very similar relationship when we look at employment to population ratios. Again, there's a very strong negative relationship where areas that have increased their detention rate over time now have much lower employment to population ratios. Again, we are not suggesting that you take these point estimates literally. We don't think that's the right way to interpret this exercise, but we do think this is consistent with the idea that our well-identified estimates have macroeconomic implications. Now, if we were to take this overly seriously, which again, we're not suggesting that we do, the numbers are enormous. I think there's every reason to believe that these numbers are probably not the right numbers to use, and we'd rather rely on the IV estimates. But again, they're very much consistent with the idea that there are very large and serious consequences of pretrial detention policies in this country. And as we have more punitive detention policies, we seem to also have worse economic outcomes, again, particularly in disadvantaged communities. Now, the last thing that we do is to start doing even more tentative exploration into what's happening to children. And so for here, we only have intergenerational mobility data for one set of cohorts. So we're not able to look at changes over time, but we can ask, were detention policies in 1990, when many of the children in our data were young, are those correlated with intergenerational mobility rates later in life? And so here we're leveraging the mobility data that came out of Raj Shetty's work at Opportunity Insights. So again, consistent with our argument, particularly for Black individuals, areas that have very high detention rates in 1990 also seem to have much lower mobility rates for those children later on in life. And again, standard errors are what they are. We're not making an overly strong claim of a causal relationship here, but certainly consistent with the idea that there are negative spillovers on the children. And so from our perspective, what really comes out of this work is that the well-identified micro results suggest really important consequences on individuals. And that seems to also show up in our macro data using the best available evidence we have. And so our results would certainly suggest that reducing the scope of the pretrial system would likely generate significant economic returns. And hopefully with work moving forward, we can have more convincing and more precise estimates of these macro effects, so we can really start to nail down exactly what these point estimates might be. But again, thank you for having me, and thank you in advance to both Conrad and Justin for the great comments.
Great. Thanks, Will. The first discussant is Conrad Miller.
Okay, hopefully I'm set up here. So thank you to the organizers for inviting me to participate in this event. It was a pleasure to read and really think about this paper by Will and Crystal, who at this point have written a series of, I think, very important papers on pretrial detention. For my comments, I'm going to focus on what I think this and related papers tell us about how labor markets work. Okay, so first let me just summarize the labor market costs of pretrial detention as Will discussed. So for the marginal defendant, they find that pretrial detention decreases the probability of employment in the formal labor market by something like 25%. At the county level, the authors look at how changes in pretrial detention rates among defendants from 2000 to 2010 relate to changes in poverty and in employment rates among prime age adults in this sample of 24 counties, and find that a 10 percentage point increase in the detention rate is associated with a 1 to 2 percentage point decrease in the employment rate. Now, as Will outlined, there's a sense in which the estimated macro effects of pretrial detention appear to be substantially larger than the micro effects, subject to the caveats that Will mentioned. And this would, suggest potentially large negative spillovers. I think the other discussant, Justin Wolfer, is going to talk more about this point. But I think, the authors suggest these spillovers may be driven by parties related to the defendant, potentially family and friends who, for example, may bear the burden of additional financial and caretaking responsibilities. Now, the question I'm going to focus on is this. So why would pretrial detention affect defendants' labor market outcomes? And there are a few potential channels here. So first, this is obviously a disruptive life event, which might lead to immediate job loss or loss of housing. We might also think this experience of detention itself will have some criminogenic effects, perhaps leading to future criminal behavior. We also know from audit and correspondence studies that having a criminal record makes it significantly more difficult to find a job. And in particular, as Will alluded to, there are now quite a few recent papers that I think provide compelling evidence that actually just having a conviction on your record seems to have a negative effect on your labor market prospects, regardless of actually the nature or length of your punishment or your sentence. So for example, in the prior work that Will described, they find that pretrial detention increases a defendant's probability of getting convicted without actually having that much effect on a defendant's total time incarcerated or their job stability in the immediate aftermath. And really what they find suggests that the effects of pretrial detention on labor market outcomes in the median run are likely operating through this conviction effect, which is potential kind of signal or stigma effect, which has follow-on effects on a defendant's job prospects. Another paper in this vein is Mueller, Smith, and Schneppel, who study the criminal justice practice of diversion, where instead of getting a conviction on the record, defendants can avoid a conviction by successfully completing a probation sentence. And in their setting, the marginal defendants who have their case diverted don't actually get a reduced sentence. They're just less likely to have a conviction on their record. And similarly here, the authors find large labor market gains to actually having your case diverted. Finally, Egan, Doliak, and Harvey study misdemeanor arrests and whether prosecutors that are assigned to a defendant's case actually decide to file a court charge in the first place or decline to pursue that charge. Getting charged creates a criminal record in many cases and increases the chances of a conviction. But they find that for the minor offenses that they're studying, having a file charged is not actually going to, likely lead to dramatic changes, differences in these two groups in terms of the punishment they face, because most of the people that ultimately are charged aren't going to face a significant punishment. And again, the authors find that getting charged today actually increases a defendant's chance of getting arrested again in the future. And the likely channel is that getting charged initially is going to increase your probability of conviction on your record, which is going to have, again, downstream effects on your labor market outcomes. Whoa. Sorry about that. Okay. Now, I think at face value, these findings make total sense. Of course, getting a conviction on your record is going to make it harder to find a job. On the other hand, I think each study I mentioned intentionally is focusing on situations where getting convicted is essentially a coin flip, right? That's kind of by design in these research studies. So by design, these are all situations where seeing a conviction on someone's record actually doesn't tell you anything useful about the defendant themselves, arguably. So if a defendant from one of these studies applied for a job at your company, once you knew that what the applicant was arrested and charged for, actually knowing whether they were convicted or not actually doesn't tell you much about them, including how productive they would be as an employee. And this idea that the allocation of punishment in the criminal justice system can be quite arbitrary is not peculiar to these studies. So for example, even within a state, counties vary dramatically in how punitively they treat the same criminal case. Ben Fagenberg and I found in prior work that within the same state, there are pairs of counties where you can be 2 to 4 times more likely to get a jail or prison sentence if you're arrested in one county instead of another. So same conduct, but dramatically different outcomes depending on whether you're arrested. And more generally, there's growing evidence that the defendants that are more likely to be punished are often not the defendants that are more likely to commit an offense in the future. And so with all that in mind, it's actually not clear that conviction per se is a strong signal of how productive a potential employee will be, once you know other details of their case. So that actually, I think, creates a bit of a puzzle. Why are employers appearing to put so much weight on what seems to be, quite a coarse signal and perhaps not a very informative signal? Now, here's some direct evidence that employers indeed do take convictions themselves quite seriously. So these are data from a 2003 survey of California employers. And these employers are asked whether they would consider accepting an applicant with a felony conviction. And this figure also compares their answers for other applicant characteristics. So you'll notice here, 37% of these employers will say, definitely not. I'm not going to consider an applicant with any felony conviction. Also quite a high probability of people saying probably won't consider them. This is not exactly the survey question we would want to think about this, because we'd really want to know, well, how much does an employer care about a conviction versus a non-conviction? But still, I think this is highly suggestive that conviction per se is something that employers care about. So let's think about this. Why do employers screen on a conviction, including a marginal conviction? And here are the reasons that employers give in surveys for why they would be concerned about an applicant's criminal history. So one, in some cases, there are laws that are going to prevent those with certain convictions from working in specific occupations. So for example, employers in transportation, financial services, health services, those working with children, they're often going to face laws either at the federal or more local level that place restrictions on the criminal history of the people they can hire. So this is a case where, how marginal that conviction is actually maybe doesn't matter at all, in the sense that these laws define whether a conviction per se matters, regardless of how marginal it was. Employers also report that, they're concerned about the perceived risk of negligent hiring lawsuits. So if an employee while on the job inflicts harm on a customer or another employee, employers can be sued for damages under the negligent hiring doctrine. At least if the harm that was, if that harm was predictable given the worker's criminal history. So this is another case where marginality, may not really matter, in the sense that the legal system is likely going to put additional weight on prior convictions, regardless of the circumstances of that conviction. Third, some employers will claim in surveys that they're concerned about customer preferences. So customers maybe won't want to have, they maybe don't want to interface with people who have a criminal record. Here, it's not clear how much marginality matters. It's not clear what customers would actually learn about an employee in the course of interacting with them, or what they'd care about. But finally, and what I'm going to focus on for the remainder of my time is, employers also use these convictions when they're screening for productivity, or how well an applicant is going to fit for a particular job. And in this case, it's pretty clear that an employer shouldn't really put an additional weight on a marginal conviction if they had the right contextual information about the charge characteristics. But in practice, employers may not actually be able to identify these marginal convictions. So why might that be? The simple answer is just that employers may be screening on this coarse signal, whether someone has a conviction, rather than a more refined approach, simply because it's just costly to make that distinction. So for one, it could just be gathering the data necessary to do this and interpreting that granular data. It may have these upfront costs. It may also be the case that employers actually need to learn from experience when they're trying to figure out what aspects of criminal history actually matter for predicting job performance. And so this is an environment where biased beliefs and misperceptions can persist over time, because what's going to happen is some employers are never going to hire applicants with any kind of conviction. And that means they may never learn whether having a conviction actually matters for predicting whether someone's going to perform well in the job. Now, with these costs to more refined screening, it may only be worth it to employers to kind of figure out how to do this more refined screening when there's actually a large share of their applicant pool that has any sort of arrest history. And if you think about it, this would actually potentially lead to a spillover effect going the opposite direction of what the suggestive evidence will present implied. So if you think about it, if 1% of my applicant pool has a criminal conviction, maybe it's a perfectly adequate hiring strategy to just ignore all those applicants. But if that is increasing to, say, 25% of my applicant pool, now there's a lot more incentive for me to actually figure out, how do I interpret a criminal record? What aspects actually matter for my position? And finally, I think it's interesting to contrast this issue with ban the box policies, where there's evidence that employers are hungry for information about criminal history from these policies, particularly if you think about this great correspondence study by Egan and Starr. So there seems to be tremendous, demand for this criminal history information, yet it's kind of less clear from considering this conviction margin that employers actually know how to use that information. So in summary, the authors of this paper document large labor market effects of pretrial detention. These effects are at least in part driven by employer behavior. Yet I think the evidence suggests that given available information, conviction per se is not that informative a signal. And so what do we learn from that? Well, employers appear to be responding pretty strongly to what looks like arguably an uninformative signal. And this could suggest either that employers are actually responding to just the legal considerations on whom they can or should hire, or it could tell us that they really have significant misperceptions about what information a conviction actually conveys. So I'll stop there. Those are my comments. I think this paper was a pleasure to read. I find it quite thought-provoking, and I look forward to talking about it more.
Thanks very much, Conrad. The second discussant is Justin Wolfers. Got it. You're still muted, Justin.
I love it when there's a cartoon that can really just summarize a whole paper. And, here's the judge, and he's just saying, since this is your first offense, and importantly, you've not yet been found guilty, so this is pre-trial, I'm going to be lenient in my sentencing. And really, that's the starting point of this paper. And the starting point's actually the 2018 AER paper by Will and Crystal with a co-author, Golden. It's an unbelievably good and careful paper in which what they're interested in is the effects of pretrial detention on longer run outcomes. And so the way they get at this really high quality causal stuff is there's random assignment of who your judge is on a given day. That's the random assignment there. And if you're unlucky, you get the hanging judge. Hanging judge is going to throw you in jail straight away while you await your real trial. And that may lead to bad outcomes. And of course, they can see this because there's a control group. There's a bunch of people who got the lenient judge. The lenient judge put them out on pretrial release, and we see that they have better long run outcomes. And so this is just incredibly convincing evidence that if you are given pretrial detention, you will have much worse outcomes. So in other words, this is a very clean identification of the direct effects. But of course, for policy, we care about a lot more than the direct effects on the person who's put away. And so today's paper really is, well, we've got this wonderful paper on the direct effects. What about the broader spillover effects? What about the effects of this on others? Sometimes we might call this partial versus general equilibrium, but actually a lot of these spillover effects are even sort of partial equilibrium. So really, the whole paper is very much a metaphor for the difficulty all of us have when you get these incredibly well-identified micro studies, often done by labor economists who've managed to slip something, who've been well-educated by the identification police. But how do we then get those well-identified studies to speak to policy issues, which unfortunately operate in a macro general equilibrium world? So I'm going to say three things, and the truth is I'll probably just say two. The first question I want to ask is, are these macro spillover effects actually plausible, the ones that Will presented? And then I'm going to argue they're not, and I'm going to suggest actually a reasonable prior is that the spillover effects may even go in the opposite direction. So look, here's the starting point. This again is the 2018 AER paper, in which he finds that if you're detained, the chances of you working, and this is 3 to 4 years later, is about 10% lower. So in a given year, there are 10 million people arrested. 37.8% of them are detained. if detention reduces employment by 9.4 percentage points, that says if we got rid of pretrial detention, we would raise employment by 355,000 people, right? Now, actually, that's probably an overstatement. So let me just do some sort of second order stuff. I started off by saying 10 million people are arrested, but actually there's 10 million arrests. Lots of people are arrested many times. So a reasonable guess is that actually the true number of people arrested is half that. And I'm going to spend most of my time talking about the outcomes I know how to interpret best, which are the effects on the employment rate. Will was looking at the employment rate of those aged 25 to 54. Now, they're only 57% of all detainees. The final thing is he focuses on this coefficient here, which is the effect of employment 3 to 4 years later. In the original paper, it turns out he has actually two coefficients. One is what are the effects in the first 2 years after pretrial detention, and the effects in the subsequent 2 years. And the latter turns out to be big and the former turns out to be small. So I don't know what to do with two coefficient estimates like that. So rather than just pick the big one, what I did was I took a precision weighted average. And the precision weighted average of those is actually only 60% as large. So now we take this 355,000 people and we scale it down accordingly. And this says that if we got rid of pretrial detention, it would lead to about another 60,000 jobs, workers among those aged 25 to 54. 60,000, keep that number in mind. Because now we want to move to, that was the first study. What are the individual micro effects, the direct effects? Now, if we want to get to the spillover effects, we're going to have to look at what happens at whole communities. And that's what this paper is. This paper looks at the change in employment rates over a 10-year period against the change in the detention rate. And it does this by looking across counties. So you figure if all the spillover effects are within county, this is going to show you the full effect, the direct plus the spillover effects. Will just showed you this slide. He says employment, taking the regression coefficient seriously that he just showed you, it says that the employment rate, if you got rid of cash bail, would increase by 7.5 to 10 percentage points. That's an increase in employment to population ratio. That's staggeringly large. Now, I think he's slightly miscalculated. So I'm actually going to take his numbers. I'm going to scale them back to what I think they are. And so the employment rate, I think, actually only increases by 3.6 to 6.4 percentage points. This is using his smaller coefficient. This is using his bigger coefficient. Okay. So I'm reducing what he does. Now, it turns out in 2000, when he's looking at long differences since 2000, there were 63 million 25 to prime age people working. And if getting rid of pretrial detention would cause the employment to population rate to rise by 3.6 to 6.4%, that means it would create another 2.2 to 4.1 million extra jobs. Compare that to the direct effect, which was 60,000 extra jobs. So it looks like the indirect effects, the spillover effects, are 35 to 70 times larger than the direct effects. This just seems too large to be plausible to me. Now, what I'm going to do is I'm going to try as hard as I can to reconcile. So let's try and figure out, the micro study tells you what are the effects of being detained on your employment in a specific year. What does that mean in a steady state? Well, if detention only has effects on 1 year, losing 60,000 jobs for 1 year will only cost you 60,000 jobs. If that scar sticks with you for your entire career and there's on average 30 years left in your career, then we want to multiply this by 60,000 and say the direct effect will be 1.8 million jobs. Now, I suspect it's unlikely that when you're 60, that you're not going to get a job because of a crime you committed when you were 24. So I suspect actually the scar depreciates. So I made up a number. Let's say that the scar depreciates 10% a year. That says the direct effect can get you to 600,000 jobs. So far, so good. Now, remember the direct plus the spillover effects, I told you was 2.2 to 4.1 million jobs. But that's what would occur if all of those effects occurred on the first day of his sample. Typically, you'd expect things to change slowly. And so when things change slowly, the average effect turns out, which is what the econometrics measures, turns out to be half the steady state effect. So that says the total effect would be 4.4 to 8.2 million jobs. So again, the spillover effects look to be 10 times larger now than the direct effects, which still seems too large. Let me give you another way of thinking about how large they are. Here's the employment rate of 25 to 54-year-olds. The financial crisis caused that employment rate to decline by 5 percentage points. Will and Crystal are arguing that if you eliminated cash bail, it would cause the employment rate to rise between 3.6 and 6.4 percentage points. So they're arguing that this one small part of the labour market has an effect as large as the financial crisis and nearly as large as shutting down the entire service sector of the economy. So this seems sort of too large to be right. Let me say one other thing. They do an analysis separately for blacks and whites. So this is black employment against the county-wide detention rate and white employment against the county-wide detention rate. Now realize the horizontal axis is not showing a different effect by race. That's important because these coefficients turn out to be remarkably similar. The effect on blacks is, as you would expect, somewhat larger than the effects on whites, about 50% larger. But what should we have expected? Well, it turns out, of course, that inside, among people who are detainees, there are 2.3 blacks for every white. In the population, there are 5.3 whites for every black. So that means if you're looking at the ratio of detainees per capita, there are 12.3 blacks to whites. This suggests that we should have expected the black coefficient to be 12 times larger than the white coefficient. Instead, it's only 50% larger. So that suggests maybe there's something else going on here. So I'm not sure I'm convinced by the macro effects, and there's a bunch of whiny complaints about this later, and hopefully for your sake, I'll skip them. But I just want to ask, what is a reasonable prior for what these spillover effects would be? So I did the simplest thing I could do, which is I wrote down a really complicated model of the labour market. Labour supply, of course, depends on the marginal utility of leisure. Labour demand is the marginal revenue product. What would happen if we took a whole bunch of people and gave them pretrial detention? Well, it wouldn't change the marginal utility of leisure and it wouldn't change the marginal revenue product. So to a first approximation, the equilibrium with pretrial detention is the same as the equilibrium without pretrial detention. So in equilibrium, we don't expect a small number of people behind bars to change total employment. All right, that's a little bit too simple. Let's not take perfect competition seriously. What if we're in a world that has some rigidities? So here's a friction that creates unemployment. Fair enough. Now, what if we have pretrial detention? If we've got unemployment, there's a queue at the factory gate. I now get to choose who to let in. If I want to discriminate against those who've been detained, I can now do so for free. What I do is I take some of the people who previously I was going to let in and I'll stick them back out the other side, but someone else is going to come in and take their job. So even here, we'll see direct effects on the detained, which is what Will's earlier AER paper showed, but no effects on the total in equilibrium. So I'm being too simple and a little bit glib. So let's think about what pretrial detention actually does. It leads more people to be found guilty. That's what they find. And more people to plead guilty. But it doesn't actually lead them to spend any more time in jail after they've been incarcerated. What it leads to, in fact, is for them to spend more time prior to the disposition of their case in jail. How much longer? 2 weeks. So this whole thing seems like it's really small. You spend 2 extra weeks behind bars. So what must be going on? It must be that the main effect is that a criminal record is a signal or a scar. And this is very much what Conrad was suggesting earlier. So if we eliminate pretrial detention, then we suppress that signal. What are the spillover effects going to be of suppressing that signal? So here's a wonderful study by Amanda Reagan and Sonia Starr, in which they send out resumes and they say, what are the effects of having a criminal record? They send out resumes with historically black names and historically white names, and they measure the callback rate. And what you see is for both, if you have a crime, if you've committed crimes, your callback rate is much lower than if you haven't committed a crime. This is exactly what you'd expect. Right? But then ban the box comes in, and you're no longer allowed to ask people whether they've committed a crime. And so what happens now is that the callback rate for whites, all whites, goes way up, but the callback rate for blacks goes down. They can no longer signal that they're not criminals. Employers infer then maybe they are, and they become much less likely to hire them. So suppressing this signal really hurt black workers. In fact, you can see this with this wonderful paper from Doliak and Hansen, in which they look at when cities ban the box, Cities that adopted ban the box, the employment, oops, I've got these labeled the wrong way, I apologize. The employment of black men declines relative to cities that didn't. And we see no such effect on white men. All of this says that the spillover effects may actually be negative. So let me just pause there. Let me just stop there. I just want to say the big points here are these spillover estimates credible? They strike me as being incredibly large. And then do we necessarily think these spillover effects are going to be negative? And it's not obvious that they are. So I think a reasonable prior is to say the spillover effects are going to be either an order of magnitude smaller than Crystal and Will suggest, or they may even be negative. Let me stop there.
Thanks, Justin. And I'm going to open it up to questions. I give people a chance to put their hands up. And while we're waiting for questions, maybe Will, you want to respond to some of the discussants' points, or Conrad, if you want to add in some more comments after hearing Justin's comments, we can start the discussion with the panel.
Yeah.
So, Will, you want to lead it off?
Yeah, I'll quickly respond. But Justin, Conrad, thank you both, and I'll follow up afterwards. Justin, just a couple quick notes. The IB estimates are actually case weighted, so you don't want to do the deflation that way. And I apologize, we didn't explain those numbers. We're actually adding the base change in as well, so we have the same numbers as you.
Yes.
So anyway, just I think some of the deflations you're doing are not actually what we should do. But the broader point is 100%. We agree. I don't think changes on changes is anyone's idea of a lock solid identification strategy. And we would never want to interpret those estimates as seriously as the micro estimates. And like you said, that's the challenge. So I think, we're trying to provide as much information as we can and keep the conversation going. But if we wrote the paper in a way that suggested more seriousness to those estimates than we meant, then we'll definitely revise. The one thing I would say is I don't think that the implication you drew from the Agan studies, I do think that's not quite right. Because again, the Agan study is really holding the mix of people constant and is taking away information. Here, we're actually changing, who the people are in a sense. We're taking away a scarring activity. And so I do think that the implication there isn't quite mapping one-to-one in the way that, that you're suggesting.
Conrad, did you want to jump in?
I don't have any.
Okay.
Yeah.
One follow-up I had was similar to what Will just said, that Justin drew, a parallel between the ban the box policies and your elimination of cash bail. And so maybe you could expand further on the difference between those policies, or maybe Justin wants to comment as well, or other possible policies, because I think there's a debate here about the magnitudes, but it would be interesting to think about what other policy interventions might address the effect that you're identifying and that you identified in your earlier paper.
Absolutely. And Conrad, I'm going to lean on you for the second part of my reply, but I think broadly you can think of helping people in this population in at least two ways. One is to prevent the scarring effects in the first place, and I think that's really what our paper is about: is to say, well, here are changes that we could potentially make to the criminal justice system. In the AAR, we show that the changes to public safety are going to be minimal, and yet it seems like there's large economic benefits to the individuals themselves. And so if we kind of multiply that out, this seems like a bit of a no-brainer policy to actually just make these people more employable from the point of view of employers by not putting them through the scarring experience. I think the other set of policies that you should be interested in and might be interested in would be things like ban the box, where we say, holding fixed what's happened to people, how do we get them reintegrated into the labor market, particularly in light of some of Conrad's points that people are using these signals in a way that it's not obvious. It makes a lot of sense. So that's definitely work that I'm interested in as well. And I think building on some of Conrad's ideas, that could be things like increasing liability protection for employers or providing more objective information. So in other work that I've been doing with co-authors, we show that at least where we have productivity data, individuals with and without a criminal record seem like they're just as productive. Happens to be a setting where we have really fine-grained productivity data. It also seems that employers are very responsive to when we simply just tell them, it turns out that at least in this setting, people are just as productive. You're making mistakes in the way that you're screening folks. So I think, I would very much put ban the box in the category of, well, we've put people through this very scarring experience. How do we reintegrate them? Whereas I would put pretrial policies in the category of, let's avoid scarring people in the first place when there's no real public benefit to doing so.
Let me just add something here. I don't want to take ban the box too seriously as the analogy, but what I do want to do instead is just think about just a very, very simple model about what you expect the general equilibrium effects to be. So the treatment is like 2 extra weeks in jail. That's almost nothing. Therefore, it sounds like you think it's almost all signaling. So this is like we walk around and on 10% of the population, we put the letter L on their foreheads. And then we try and figure out what the long run effects of that are going to be. It's obvious that it's going to have direct effects on them if this is a socially constructed group that we want to discriminate against. For most models of the labor market, the net employment effect of putting a scarlet letter on some random group of the population, 0. So I come with a very strong prior, not that it's a negative effect like ban the box would tell you, but it's got to be awfully close to 0. And there's second order reasons why it might not be. And again, I do think it just speaks to this broader thing. But there's wonderfully identified micro studies, but then how does this play out in equilibrium?
I mean, the one thing that would give me pause is the same arguments were made about the micro estimates. Before our paper was written, the most common thing we would hear from economists is it's only 2 weeks. This can't possibly have effects 4 years later on the labor market. Why would it have any effects? So I think it speaks to the broader point that we do need better macro estimates. And I totally take the point that this paper has not gotten us all the way there where you and I will necessarily agree now, but fingers crossed, if we get invited back in a couple of years, we'll have better evidence and I can sway you with the data.
Just one quick interjection here. I think the comparison with ban the box makes this response to convictions a lot easier for me to interpret just in making the contrast, because in some sense it is pretty different in the type of information that would be obscured here if we removed pretrial detention, because what's happening, at least in the context of Will's study, is it's not as though you could get all the information about the underlying case, who the judge was that sentenced this person. In principle, you could basically get all the information you need. Yet people are responding to the conviction itself, which I think is I don't know how surprising it is, because maybe people aren't getting into the weeds as Will and Crystal are, of course, but it is kind of striking that people would have such demand for a criminal record, as is indicated by the Agan and Starr paper, but they're not. It doesn't seem like they're digging in to look at someone's arrest record. In principle, tells you just as much, regardless of the conviction outcome.
So we have a couple of questions queued up. Let's start with Steve Davis and then Erica Groshen. We have, there's Steve.
Yeah, thanks. Great paper discussion. I wanted to speak to 2 issues briefly. One is why do employers screen on a marginal conviction, much of which Conrad focused on. And there's an answer to that implicit in what Justin said that I think is worth drawing out. And that is in many settings, employers cannot benefit by paying less to convicted felons, which would increase their incentive to hire them. And so we have minimum wage laws, collective bargaining agreements, fear of lawsuits, and firms' own internal compensation policies that don't really open that avenue towards taking a chance on risky hires. And I think that's something to consider in the design of these policies and institutions. Second, let me speak to Justin's point about why the equilibrium effects might be quite small, even if we take the tightly identified individual effects as large. And I think the point is largely right, but there is one kind of effect that I don't think will get swept away in equilibrium, and that is the effect of the scarring on the incentive to accumulate human capital that makes you more or less employable in the future. And here I'm thinking about this in a broad way. If you decide to engage in, you're more likely to engage in criminal activity going forward rather than pro-market investment type activities because of this scarring effect, then that will persistently and possibly cumulatively in greater and greater force over time reduce your employability as an individual. I don't think that's an effect that will get offset in equilibrium because you're basically taking a segment of the workforce and just making them less employable, less productive in the legal sector.
Thanks, Steve. Erica Grosjean is next, and then Carolyn Hawksby.
Okay, so there are two things that I wanted to raise. First of all, actually, there's a group that I've been working with here at Cornell that is investigating the accuracy of criminal records that employers have access to, and this information is really lousy, and so it seems to me that that acknowledging how bad that information is, could exacerbate. You could imagine models where it would exacerbate the impact of that information. But the second thing is maybe another way to think about this is that it's another set of comparisons that might be useful is to think about displaced workers. In the simple model that Justin's talking about, there would be no wage impact of displacement. And yet we know that there is a wage impact of displacement, particularly for people with low amounts of education, right? And so if one of the major impacts of a pretrial detention is that you lose your job and you become like a displaced worker and additionally have this scarring effect on you, then you could imagine that that sort of thing that you're estimating is not so far off. And so that might be a comparison that you want to make.
Great, thanks. And now Carolyn?
Sure, I'll try to be really brief. I'm thinking back actually to a comment on Justin's discussion where he had his nice little graph with the unemployment wedge between supply and demand in the labor market. And what Justin suggested, which made a lot of sense, was that I displace someone from the employed pool and put the person in the unemployed pool, and then I pull someone who would otherwise be unemployed and I put them that person in the employed pool. And that all makes a lot of sense and it's very rational. But I will note that if you look at the Egan and Starr paper, it suggests that when the ban the box policy is put in place, employers more than statistically discriminate against Blacks. And so it might be the case that if we're doing this kind of employment swap, I make someone unemployed who's Black and I replace that person with a Black person. And if I make someone unemployed who's white, I replace that person with a white person. In that case, the spillover effects could be quite different from what you would expect if I were willing to draw from the pool of the unemployed at just sort of the ratios in which they exist in the unemployed. The spillover effects could be kind of exaggerated.
Great. Thanks for those comments. And that's all really helpful. And also thanks to the authors and the discussants for a terrific panel and follow-up discussion here. We're going to take a 5-minute break and we will come back at 4:10 Eastern for the cognitive skills paper and we'll hear more from Carolyn.
Thanks for watching. Be sure to like and subscribe for more videos from Brookings.